Hello friends, in the series on the income tax cases, today we will discuss a very interesting case on section 148 notices. As all we know that the complexity of section 148 notices in the context of old regime and new regime and in the context of Honorable Supreme Court judgments in the case of Ashish Agarwal and then Rajiv Bansal have become a very complex issue. And daily new situations are arising which are making the situation more complex both for the assessing officers and for the assessee. The assessee is suffering because he is in the litigation, never-ending litigation, and the revenue is suffering because the revenue is losing its revenue due to the quashing of notices and assessments by the various tribunals and courts, because the revenue is not able to understand the true crux of the judgments of the Supreme Court and the old and new regime. The main question in the present case was that whether the Supreme Court judgment in the case of Union of India versus Ashish Agarwal, which was decided by the Honorable Supreme Court on 4th May 2022, was applicable for those notices on the basis of which the assessing officer has already completed the assessment. This issue has been taken up by Kolkata ITAT in the case of GD Mother Educational Society versus Assistant Commissioner of Income Tax, and this case is reported in 115 ITR Tribunal page number 594, and the date of the judgment is 25th September 2024. In the present case, the assessment year is 1819 to 2021, and the assessing officer issued the notices under section 148 in the old regime, although the new regime was applicable from 1st April 2021, and on the basis of these notices, which were not as per the new regime, the assessing officer completed the assessment on 31st March 2022. And the assessee filed the appeal before the CIT appeal on 6th April 2022 for all these assessment orders. After the appeals were filed, the Supreme Court judgment came on 4th May 2022, and after the Supreme Court judgment in the case of Union of India versus Ashish Agarwal, the learned assessing officer issued the notice to the assessee by converting the notice under section 148, which was issued earlier on 30th June 2021, into section 148A clause B according to the directions of the Supreme Court, and completed again the assessment for all the assessment years which were concerned on 16th November 2023. Now in the present matter, there were two sets of orders. One set of orders were on the basis of old law and the other set of orders were under the new law. When the CIT appeal was hearing the matter of the assessee for the orders which were passed in the old regime, the CIT appeal took the stand that since the assessing officer has passed the new orders according to the Supreme Court judgment, so the old orders become non-est, and he dismissed the appeal of the assessee as infructuous. The assessee filed the appeal before the tribunal, and the plea of the assessee was that once the assessment orders have been passed, the assessing officer was not in a power to pass the assessment orders again on the basis of the same notice, and the plea of the assessee was that Supreme Court judgment is not applicable to the assessee in the present case because the assessment orders have been passed. When the tribunal heard the matter, the tribunal was of the considered view was that in the present case, the CIT appeal was not correct in assuming that the earlier assessment orders are non-est, and the CIT appeal should have decided the appeal on the basis of the merit. The tribunal said that in the present case, the CIT appeal has assumed the assessment orders as non-est on the basis of subsequent proceedings and thinking that the subsequent proceedings are correct. That is why he treated the earlier assessment orders as non-est. The tribunal said that whether the assessment orders which are passed and whether the assessing officer has the power to treat those assessment orders as non-est and again passing the assessment orders is a debatable issue. The tribunal said that in the present case, both sets of orders have separate legal status and should be decided separately. So, it was the opinion of the tribunal that in the present case, the Ashish Agarwal case is not applicable in those cases where the assessment orders have already been passed, and since the CIT appeal has assumed that the earlier assessment orders will automatically become nullified on the basis of the subsequent proceedings, so the CIT appeal was not correct in that approach. The tribunal said that in the present case, since the earlier assessment orders had been passed on the basis of a notice which was dated 30th June 2021 in a form which was not applicable on the assessee, or on a law which was not applicable on the assessee, or a law which was not applicable as on date, are not as per law, and those assessment orders are liable to be quashed. So friends, the crux of the case is that Ashish Agarwal case is not applicable for those assessments which have been completed on the basis of the notices issued between the period 1st April 2021 to 30th June 2021. At the end of this video, once again I am repeating the name of the case. The name of the case is GD, Mother Educational Society versus Assistant Commissioner of Income Tax, and this case is reported in 115 ITR Tribunal at page number 594, and the date of the judgment is 25th September 2024. Thank you friends.